Justice, the condition of being morally correct or fair, has been a requisite condition for peace, stability, and progress of human society. And the judiciary, through which the state administers its laws and its justice, is often said to be the guarantor of justice and the last bastion of hope for the common man. It is the institution that holds the balance between competing interests in society so that disputes are settled peacefully and laws enforced, and society does not descend into chaos and anarchy, with everyone pursuing justice their own way. How well the justice system upholds this balance and mediates disputes between citizens or between the state and citizens will decide how much faith people have in the judiciary and indeed in the state and in democracy and the rule of law. The judiciary struggles to meet the yearnings of the Nigerian people for meaningful justice as well as earn their trust. Trial delays, among other factors, continue to frustrate the court users. In 2021, Access to Justice, a justice advocacy group working to defend rights of equal and non-discriminatory access to justice, as well as address corruption in justice administration, produced a report titled Judge Transfers and Their Adverse Impact on Justice Delivery and Public Trust, which focuses on the transfer of judges in two courts, the Federal High Court and the National Industrial Court.
Judicial transfers has to do with movement of judicial officers, mainly judges, from one division of the court to another division of the court.
Transfer of judges is inevitable in our environment. One, the judges don't last forever. The people die, for example, and their positions need to be filled. People get sick and they can't work for some time. They need people to fill it. People get appointed to higher benches as well, like from High Court to Court of Appeal. They leave a vacancy. Somebody has to fill it. So in trying to do that, it may require you to move judges from one division to the other. Our judges sit in divisions, mainly over the country and at the national level. So those are legitimate reasons for transfer. There is also the character of Nigerians, the principle of fairness, where people think that certain divisions or certain places are better than the other. Surely, economically, Lagos is more viable, Abuja is more viable than some other places in the country. You have better light, better power, better infrastructure, even though it's also more expensive in some places than the other. So people love to move to places that they think will better their standard of living.
The report notes that judge transfers contribute significantly to the delays in the trial and conclusion of cases in court.
Transfer of judges has a debilitating effect on the administration of justice in Nigerian courts. When judges are transferred from one court to the other, many a time they're transferred out of the judicial division. Sometimes, if it's a federal court, they're even transferred completely out of the region. You could have somebody transferred from the Federal High Court in Lagos to the Federal High Court in Kano or in Jigawa State. So, and what that means is that the effort that litigants who had their cases pending before that judge who has been transferred, the effort they have put into proving their cases up until that point, the costs they would have incurred many a times goes to waste and they have to start all over again.
It is estimated that cases can take anywhere between 1 to 18 years before they are resolved, and these make the judicial process a frustrating experience for citizens, many of whom would rather forgo any claims they have than go to court to enforce them.
The incident that actually led to the case. The dismissal or process actually started sometime in October. I thought it was a joke, but by December 2006, I was given a letter of termination, not even a letter of termination, a letter of dismissal And I thought it was a loud joke. The process was on for a while. I didn't really want to take them to court, not until they called me into a session and said, you know what, even if you go to court, you will not get judgment for the next 10 years. All right. That was very, very sad. And I decided to actually take them to court. It's just for the judge to give his decision. And all of a sudden, that same judge was transferred. What amazes me was the court process, the delay and everything when somebody tells, oh, you'll not get judgment in 10 years. And really, judgment never really came until about 10 years.
The particular case I was still involved in, I went to court. The matter started very early in 2017. It's been 5 years now. The judgment was reserved in the matter, and we were waiting for that when suddenly we heard that the judge had been transferred to Owerri. They actually reassigned the case to a new judge. Well, of course, it meant the case had to start all over again, you know. This is after time had been spent, plenty of money had been spent, 5 years had gone by, and then they say we have to start the case all over again.
But why are trial delays such a chronic and strangulating problem in Nigeria's justice delivery system? Access to justice suggests that the judiciary is a major cause of the problem of trial delays.
From the findings from this research, we discovered that in various ways, judicial transfer adversely affects justice delivery system of the court and also the public confidence in the judiciary. Basically, we discovered that one notable area it affects it is in terms of time of dispensing with cases before it. So there's always, it brings about protracted trial time.
Access to Justice report shows that administrative arrangements that should have been made for reassigning judges to other courts are often not made by court bureaucracy. Rather, the courts place the burden of initiating the transfers of these cases on litigants themselves. If the litigants don't do these, the cases stall.
As the report did say, when judges are transferred from one jurisdiction to another, the courts are not very efficient in either reassigning those cases that are transferred or in granting what they call fiats for the transferred judges to continue trying these cases in their new jurisdictions. Or even in cases where they have reassigned these cases, for these cases to be put back effectively on the new court docket actually takes a bit of time. In between any of these processes that I've just talked about, it could take sometimes up to 3, 4, 5 years to get a case back on track after judges have been transferred. That's very disruptive of the trial process. That increases not just the time it takes to conclude those cases, but the cost as well. You can imagine that litigants will have to bear this cost.
What if your case has been going on for 5, 6 years before a particular judge who is transferred from Lagos to, as I said, Enugu, and you think about how to start afresh, and then by the time you get to another 6 years, that's 12. But you might then tell yourself, well, I think if we continue with this particular judge, then I'm likely to be getting a judgment rather than start afresh with a fresh judge. So it's not an easy question to answer, but it shows you the dilemma that people who use the courts have to go through. It's part of the constraints that, makes people speak, in less favorable terms of the judiciary, because what people want in the judiciary, just like when you go to the doctor to cure malaria, is an instant treatment. But if you have to take 6, 7 years to cure illegal malaria, why would I want to go there? So the perception of the courts as a place where things never work is a very high perception in the minds of Nigerians.
Some of the factors include the time taken to reassign a case to another judge after transfer is made. Another issue is the pervasive slackness of judicial bureaucracy, prolonging the time taken before a fiat is granted to the parties seeking for the transferred judge to continue and conclude the case.
The administrative system of the court takes quite some time in reassigning cases after transfers have been made. For some cases, we discovered that it takes about an average of 3, 4, sometimes even a year to reassign cases that are involved in this transfer.
Sometimes by the time you get into the trial of a matter, you find out that some of the witnesses that you want to rely on to provide your evidence are no longer available. Either they have been transferred, or either they are sick, and sometimes they even die.
Why the need may arise to transfer a judge from one division or from one court to another. The question is that power being exercised in a manner that takes into consideration the debilitating effect of such transfers on litigants and on the justice sector as a whole? I think for now, the evidence is that it is not being given sufficient consideration.
Prolonged delays in concluding cases filed in courts oftentimes have staggering effects on court users and leave them frustrated or disillusioned.
It's really, really painful. You started out something as a young man and you didn't get judgment until you are in your 50s.
I'm not happy about it at all. They say justice delayed is also justice denied, After all of the money spent, all of the time gone by, I don't know what's going to happen right now that's going to give me a sufficient compensation, money that had greater value at the time. You would have to look at the economic situation that we're having now and what the value of that money was at the time and what it will be now, even if I recovered the whole thing now.
Are delays unavoidable and insurmountable? Is the judiciary doing all it can to ameliorate them and keep them to their barest minimum? Certain practices undertaken by the judiciary itself suggest not.
There's nothing more frustrating, and even, for us lawyers as well as for our clients, when due to no fault of yours, and I've had live direct experience with this. There's a matter which is still ongoing, which our firm was conducting in the Federal High Court before Honorable Justice M.B. Idris. That matter had reached, we'd adopted our final written addresses. So the matter was adjourned for judgment. And then Justice Idris was elevated to the Court of Appeal. And that was the end of the matter. We had to start all over again. So you can imagine this was a matter in which we had brought in expert witnesses. We had tendered loads of evidence. Our client, and it was a matter that had significance. It was an aviation accident. So even giving evidence of the matter was harrowing for the client because he had to relieve all the horrors of the loss of his loved one. And then he had to go through the same thing all over again just because the judge was transferred after the matter had been adjourned for judgment.
In one of the cases, I recall that by the time the trial ended and the litigant won judgment, the litigant couldn't enforce this judgment because by that time, the corporation that was sued and for which the judge awarded judgment to the litigants, the corporation had wound up. They were no longer in business. So all the victory that the litigant got was actually quite hollow.
The justice system in Nigeria today faces many questions as to its capacity to deliver justice, uphold the rule of law, defend constitutional democracy. Nigeria's constitution envisions that all people shall have access to timely justice, regardless of their status. There may be no perfect judicial system, and there are other factors that contribute to courts operating slowly. But given that the judiciary's unique and important role in safeguarding constitutional rights, the judiciary must never put itself in a position where it constitutes a barrier to the rights of citizens to obtain a speedy trial or a major violator in the very rights it exists to safeguard.
Access to justice is a human right. It's everybody's responsibility. It's a fundamental human right, access to justice. But in the profession, the bar association should lead it. It's an objective in their constitution which they have to confront head on. Because apart from the access to justice or the justice implication of it, it's also what diminishes their living standard. So they should champion it.
The judiciary that ought to be in the forefront of protecting the rights, citizens' rights to a speedy hearing, is actually, a major impediment to the realization of that right. And I think this ought to concern the judiciary much more than it is doing at this time.
We need to move away from this perception that the judiciary is the exclusive preserve of judges or of judicial officers, and realize that the judiciary is actually too important to be left to just judges alone. Yes, judges have the exclusive preserve to adjudicate, but the management of the judiciary really ought to be outsourced to professionals. Let these professionals be answerable to the judges, but let's outsource the administration of the courts to people who are better suited and who are more capable of ensuring efficiency.
Access to Justice argues that judicial transfers can be done in a more thoughtful, efficient, and accountable manner. Much better planning should inform and attend decision-making on judges' transfers, and the leadership of the courts concerned must, prior to making transfers, undertake an assessment of the impact of such transfers on court dockets.
They need to create a guideline that governs and outlines the processes for transfer of judicial officers. This guideline should state the basis for the transfer, the conditions for such transfers, as well as the implementation, the process, the conditions for implementing such transfers. Also, there could be an impact assessment of the docket of the court. Then another is to have a fast-track system, whereby once this transfer memos are communicated to the affected judges, then they set down cases that are part-hard cases before them. They set them out and give them fast-track hearing.
Let the Constitution make it empower judges, us to allow judges, a judge that did not hear a case, make that determination by just reading the records without that long, tedious process of the Evidence Act. The system must digitalize our litigation process. The evidence must be recorded digitally, not what we are doing. What we are doing now is what is giving rise to these problems, where the judges still record people in longhand.
The lawyers don't necessarily have to ask or write for fiat. There should be special arrangement where cases are not dispensed with. There should be special arrangement for these judges to quickly return back and conclude on those matters. And within this period, new cases are not assigned to the judges so that they concentrate and conclude on matters pending before them. In areas that have to do with trials that have already taken place, the witness testimonies should be documented in such a way that the demeanor of the witnesses are also well stated by the presiding judge, such that the new judge can easily pick up such evidence and admit it and work with it in delivering his judgments.
I need to see judges being really monitored and appraised appropriately. To say you have 6 cases. Why were these 6 cases not treated in 4 years, in 3 years? Why were judgments not given in 3 months?
A judge, of course, can be transferred, but do you have to start the case all over again? Especially when you've gotten to that point where it's for judgment. Why are you going to start all over again in a fresh court? If there's a way the judicial, the people in charge of the judiciary can, apart from not allowing this repetition of cases to happen, to also expedite cases, in court, so that there shouldn't be this much delay.
Once cases get into the courts docket, it's the responsibility of the judicial branch of government to manage the conclusion of those cases. And particularly when those cases are disrupted by the courts themselves and the administrative decisions they take on, relating to their judges. So when you are taking those administrative decisions, it is incumbent on the courts to also proactively act on the cases that will be affected by the transfers of those judges. Don't wait on litigants. It's not the litigant's responsibility. It's not the litigant's responsibility to clear up any mess that the judiciary has created. The judiciary ought to do so itself.
Nigeria's judiciary needs all the change it can make to win back the waning public trust, and there are low-hanging fruits it can reach in efforts to re-inspire public confidence in its institution. Reforming how judges are transferred and reducing the collateral impact of such transfers on court users is an important step in that journey.